Complete this rhyme. Twinkle, twinkle, little star.
How are you working? How?
Who's that?
Welcome to The Point of View.
Welcome to Face to Face on Channel 1 Television.
And hello, welcome to What the Papers Are Saying.
This be football made in Ghana. It be the only pidgin show where it day on your screen. Channel 1 TV.
Thank you so much.
Some people are late. You know, they have to catch up. City TV is now Channel 1 TV. You understand?
This is Channel 1 TV, telling your story, empowering change.
Complete this rhyme. Twinkle, twinkle, little star.
How are you working? How?
Who's that?
Welcome to The Point of View.
Welcome to Face to Face on Channel 1 Television.
And hello, welcome to What the Papers Are Saying.
This be football made in Ghana. It be the only pidgin show where it day on your screen. Channel 1 TV.
Thank you so much.
Some people are late. You know, they have to catch up. City TV is now Channel 1 TV. You understand?
This is Channel 1 TV, telling your story, empowering change.
Hello, good morning. Welcome to The Big Issue, your platform for incisive analysis and riveting conversation. My name is Selorm Adonoo. This morning, we have two key issues on the table. The first, which is very obvious, has to do with the Supreme Court decision in respect of the 4 seats in Parliament that were declared vacated. The Supreme Court has ruled that the seat should not actually be vacated because the construction of that provision, 97(1), G and H, as rendered by the Speaker, was erroneous and unconstitutional. The Supreme Court, however, did not make any consequential orders. That has spawned quite a number of issues and discussions. What is the Speaker supposed to do? Has the matter effectively been resolved? What about the issue of jurisdiction? Should the matter have gone to the Supreme Court or the High Court, which has jurisdiction to deal with matters of parliamentary issues like this one, vacation, whether somebody is properly elected, etc. We'll delve into all of that this morning with very seasoned minds in this matter. Also, we'll look at the campaign trail. We'll want to this morning do an assessment on the healthcare proposals of the two key parties, the NDC and NPP, particularly look at what has become known or is becoming known as the Mahama Cares, and also the fact that from the 1st of December, we'll start having free kidney dialysis. People have said that one was done to preempt the other. We do not know. We will want to understand the thinking behind these two major policies. What then happens from there? What is the source of funding for this, amongst many other things? The show, as always, is live and interactive. You can join the discussion via WhatsApp lines 020-444-7033, and same has been displayed on your screen. We'll be happy to read out your comments to the rest of the world. I'll take a short break, return, and provide some updates, introduce my guest, and we'll get a discussion underway. Once again, you're welcome. This is The Big Issue.
Another morning, another day filled with possibilities. My old car reflects my journey, and today could be the day I take a big step forward. Anything is possible. Just think about it.
My shelves are ready to be filled, and soon the flat rate will open up exciting new opportunities. I can already envision a vibrant shop bustling with customers, all eager to discover what I have to offer.
I feel optimistic about import costs. Why? Because with DMB flat duty rates, my expenses will be more manageable. I can see my business thriving.
Every moment spent with my son brings back wonderful memories.
I tell you, my son, with my digital skills, now one can create games in the website.
Esuro, boot number 1 on the ballot.
Yeah, welcome back. This is The Big Issue. Two key issues we are dealing with: the Supreme Court decision on the 4 seats that the Speaker declared vacant. The Supreme Court says that the Speaker couldn't have done so. The Speaker exceeded his jurisdiction in doing so. The Supreme Court also assumed jurisdiction in dealing with the matter when others have thought that the Supreme Court itself did not have jurisdiction. Indeed, the dissenting opinions on this matter, read by Lovelace Johnson and Amadou Tanko, JJSC, pointed that out. Nonetheless, 5 justices of the Supreme Court thought otherwise, and so went ahead, assumed jurisdiction, and then pronounced on the substantive matter. They said the Speaker could not have done so, and that provision, the 97(1)G and H, were in reference to the 9th Parliament, or a futuristic Parliament. We will look at all of that this morning. Also, we'll look at the matter of the healthcare proposals in the manifestos of the two political parties. The government, or the governing party, led by Dr. Bawumia, who is also the flag bearer of the NPP, announced recently that from 1st of December, dialysis patients will begin having dialysis for free. And that appears to have taken some win out of the sail of the Mahama Cares program. The Mahama Cares program, you understand, has a number of non-communicable diseases or huge communicable diseases, non-communicable diseases, kidney matters, and a lot of others in there. By taking out the kidney dialysis, it does appear that that balloon is being punctured or not. We will delve into that. What will be the funding source now that the government wants to do so from 1st December? How sustainable is that going to be? Is that going to be the way to go, that henceforth any matter regarding dialysis will be free? If you recall, just a couple of months ago, the center was shut down for $4 million in the owed. So 4 million cedis, if you owed 4 million cedis and so you shut down the place, how then are we going to do this for free? What has changed? What is the funding source? We want to understand that today. So these are the two issues we'll be looking at. But let me provide you some updates. Now, the Supreme Court of Ghana in a 5-2 decision has ruled that Speaker Alban Babin's declaration of 4 seats as vacant is unconstitutional. At a brief session on Tuesday, November 12, the Chief Justice Gertrude Torkornoo stated that the Speaker's declaration could not stand. Channel 1 News' Jude Duncan was at the Supreme Court and filed the following report.
The Supreme Court today ruled against Speaker of Parliament Alban Babin's decision to declare 4 parliamentary seats vacant, siding with a challenge brought forward by plaintiff Alexander Penyomarkin for interpretation on Article 97, Clause 1, G and H. In Tuesday's ruling, the 7-member panel presided over by Chief Justice Gertrude Torkornoo delivered a 5-2 majority decision in favor of the plaintiff Alexander Penyomarkin. Justice Avro Lovelace Johnson and Justice Ibrahim Amadou Tanko were the 2 dissenters on the judgment delivered by Her Ladyship Gertrude Torkornoo.
By court, in a majority decision of 5-2, Lovelace Johnson JSC and Amadou Tanko JSC dissenting on the issue of jurisdiction, the plaintiff's action succeeds. The full reasons and orders of the court shall be filed with the registrar by close of day tomorrow, 13th November 2024. This is the judgment of the court.
The dispute revolves around Speaker Babin's interpretation of Article 97, Clause 1G and H of the Ghanaian Constitution, which he cited as the basis for declaring the seats vacant. The move was met with legal and political pushback, with Penyomarkin arguing that the Speaker of Parliament had exceeded his authority. Counsel for the Speaker of Parliament, Thaddeus Sori, today did not also show up in court. Lead counsel for the plaintiff, Joe Gatti, expressed his satisfaction with the decision of the court to overrule the orders of the Speaker of Parliament.
Well, I mean, I think I've been in law for too long. I accept decisions as they come. I mean, if they had ruled against it, I would have accepted it. I've come to realize that in this matter of law, you must accept decisions as they come. You go to court and a judge is engaging you, questioning you. You may think that the judge doesn't like you, so to speak. But you'll be surprised that that judge will rule in your favor. Maybe you needed some clarification. Some of the judges too will heckle you, and then they will go the way you expected them to go. I don't want to comment on that, but I think that what I'm saying, people understand. If you listen to what happened yesterday and you see it today, you understand what I'm saying.
Majority Leader Alexander Penyomarkin, in an exclusive interview with Channel 1 News, explained the next line of action for the MPP caucus.
Several efforts were made by my good self and leading members of our party to engage Mr. Speaker, behind the scenes to avoid this. But he decided to express his opinion. We don't hold anything against him. We believe that he's expressed his view and we disagreed. We've come here. Even the court itself, 7 of them, 5 agreed with us. 2 of the view that, yes, though the matter has substance, but it should have gone to another forum. So that's the beauty of it. And lead counsel, former Attorney General and senior colleague at the bar and senior member of Parliament, Honorable Joe Gatti, expressed that in his interview, which is what has become the law. So today, all reliefs have been granted. What we expect is that our friends would respect the ruling of the court so that we move on. And then also, you as a media house, you have a responsibility to educate the public and explain issues to them. And then also, I think we take this opportunity to let go what happened yesterday, the disagreement we had, because
Honorable, finally, Honorable, so finally, Order 53 of your standing orders gives you the power to trigger a recall of Parliament. Well, when should we expect that?
We have just completed this process here. I am sure we would engage. It's time to engage. It's time to allow deeper reflection.
The Majority Chief Whip, Frank Anodompre, later addressed journalists, emphasizing the importance of respecting the Supreme Court's decision on the vacated parliamentary seats, calling for adherence from both the Speaker of Parliament and the NDC caucus.
what we expect our colleagues to do, I don't expect anything different from they complying to the judgment. Of course, when a case involving the minority leader and the court ruled, not necessarily the Supreme Court, but it was a court ruling, they were celebrating it. I expect them to celebrate with us. They must be seen to be celebrating this victory, which gives a definition to true parliamentary jurisprudence. That we expect them to do. I hope you are listening. Yeah, so our colleagues, we expect them to celebrate with us, and also to celebrate not with us, with the Ghanaian people, that this is democracy. And for the Speaker, with his caliber in wake, I don't expect anything different. So those who say that, what about if he doesn't respect the judgment? I don't think it's an option at all.
All right, so you heard that report there by Jude Mensah Duncan. My guest on the show today, Samuel Atachi, a member of Parliament for Iboakwa South, also a member of the legal team that waged a matter in favor of Afenyo Markin. Beatrice Annan, Deputy Spokesperson, the John Mahama campaign team. Dr. Srem Sai, who is a senior lecturer in public law, University of Ghana School of Law, and also a member of the Speaker's legal team. Franklin Kujo, President Imani Africa, and Dr. Ezekiel Obin Ajekum, who is a member of the MPP Manifesto Committee on Health. Gentlemen and lady, you're welcome to the program.
Thank you.
Yes, I start off with you, Beatrice. You are in studio.
I thought you start with the lawyer, the one on record.
No, I mean, you are in studio, so let me just take
fine,
preliminary comments from you. All right, so this decision, we've been waiting for it. It's been weeks. Parliament was not working well. I mean, Parliament had been adjourned sine die, and a lot of issues were talked about, government business stalling, etc., constitutional crisis and all of that. Finally, we've seen the end of it. Also, preliminary thoughts in just a minute about the decision of the court Monday, Tuesday, and then eventually seeing the reasons on Thursday, I think.
I think that it's an aberration of long-standing legal principles, as we all know. I think that it gives credence to the perception that this court and the Tokonu-led court, it's only interested in doing the political bidding of the MPP. I think that once again, the Supreme Court missed an opportunity, a golden opportunity to uphold and advance our democracy. And they missed one of the greatest opportunities that would be to consolidate our democratic gains. I have read the decision of both the majority and the minority. And I have appeared before Justice Asaridako a number of times in the commercial court. I think that with all due deference to him, he struggled to make meaning of constitutional principles.
In this matter?
In this matter, he struggled. You could see that his constitutional appreciation was not that deep. And I'll have the opportunity to demonstrate why I say that. And I can only say that they did not do the country proud. I think that if lawyers in other jurisdictions and in common law jurisdiction take this decision, I am clear in their mind that anybody will come to one conclusion, that the executive wanted a particular outcome and the judges struggled to justify that outcome. What we had, and you could see from when they wanted to go on the tangent of purposive interpretation. I think we all went to law school. We all studied constitutional law. The Supreme Courts have had the opportunity to decide on a plethora of matters that, I mean, are in the nature of this, and they missed the golden opportunity. There is nothing beautiful about what they have done. I think that when they look back in 20 years, they will not be proud. Because you see, as law students, one of the things that would make us proud is when we are reading the decision of JSC SOA into Foreign Attorney General, how that decision was beautifully written. You come down to MPP versus Attorney General. You come down to even the 31st December case, and you realize that the judges of old demonstrated fidelity to the law, even when people thought those decisions were political. What we have is something which is not beautiful. And I'm not proud to say it as a lawyer. It's not beautiful. This morning, I had the benefit of listening to Justice Atuguba, and you could sense the anger in him. And if you read the dissenting opinion, Justice Tanko says that he hopes that in the near future, this matter will be reversed. And I hope and pray, because this cannot be part of our jurisprudence when it comes to constitutional matters.
Very well. Let me speak to the Honorable Atacha, MP for Abuaka South, a distinguished private legal practitioner as well, and also was a member of the Apenye legal team. Honorable, good morning. Welcome to the program.
Good morning.
I know you should be happy because the position as it canvassed before the court has been upheld. What are your initial thoughts about this decision, and also all that people have said regarding the decision after the reasons were made available?
Well, my good fortune is not that we won, but the Constitution was upheld. And my first reaction to what my sister who just spoke is that they shouldn't rubbish the judiciary. See, because she's talking about the Tokono-led court trying to do the bidding of the executive. I find it distasteful, because people might want to talk about the Atuguba-led court that gave you, the election petition, the judgment election petition. And then when we go to the court of this, under the Constitution, and we secure a decision in the ambulance case, two decided against the Attorney General, and the court is sound, the court is doing well. We cannot go on like that unless she's interested in getting a C.Edu Ketia as Chief Justice so that he will write decisions for NDC. These are distasteful comments.
I said Ketia is not a lawyer, he's not a judge.
I'm saying so. That probably might be the wish of somebody. Because at the end of the day, what are you saying? That the justices looked at the law, and it should tell you, some people say the Supreme Court is predictable. There are two who are thinking differently. That means the Supreme Court is not predictable at all. And they are permitted within the Constitution to state their position, support it with authorities, and come to the conclusions they want. So this is what I want to say. I am of the view that if you are trying to do what you might want to call preferential justice and convenient justice, then you will never be happy with any decision that in the view of one political party is against them. This is not how the justice delivery system is supposed to be. But let me tell you what has happened that should make everybody excited. You see, we have elected to be ruled by a constitution, not a man. So even the Supreme Court hasn't gotten supremacy over the Constitution. It is what the Constitution says that we should all comply with for the sanity of our democratic dispensation. This is very critical. Do you know what that means? It means that it is not the pleasure of a man which holds sway. Like a Christian saying that I don't believe in the Bible, then how are you a Christian? Or a Muslim saying that I don't believe in the Quran. How do you become a Muslim then? So it's the rule of the Constitution, not the pleasure of the man. So what was before the Supreme Court, if you look at it critically, was that my venerable speaker, a very good friend and a mentor, somebody who talks to me a lot, he extend himself onto a court and make a definitive pronouncement that the 4 members of Parliament have vacated their seats. Could he do that? When in interpreting Article 97, 1, G, and H, it is a judicial matter. When did the legislature become a court? That is what we should look at. So therefore, if Parliament via the Speaker is becoming wayward and veering into areas not defined by the Constitution is an omission or a conduct under Article 2 that the Supreme Court should look at. So that is the purpose of the case. And any other thing that you might want to say or just not sit with the law. So this is what has happened. Now, can a Speaker of Parliament, sitting as a Speaker of Parliament, make judicial pronouncement? Because if you even look at what the dissenting views are, the import of the dissenting views are clear. If we go by the dissenting views, there is a High Court that can declare vacant seats. The two justices who dissented are telling the whole Ghana that the Speaker was wrong, although they didn't say that. The dissenting views are saying that it is the High Court that can pronounce on vacancy of seats, not the Speaker. So the aberration of the Speaker is so obvious if you look at the composite decision of the Supreme Court, that of the 5 majority and the 2. And people should make it very, 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 very clear that we shouldn't mix the issues at all. That the Speaker is not a court of law. The Speaker cannot profess to have judicial powers, because the judicial powers of the land are vested in the judiciary and not the Constitution. So for me, it is the rule of law which has prevailed, and it is important. And guess what has happened? There's a very serious matter that came up, and that gave the Speaker the space to sit as a Speaker. And if you dared, to disobey the Constitution, the under Article 3 of the, 2-3 of the Constitution, you can have a situation in which you could be jailed. And it came from a very serious, jurist that they respect. The NDC respect you so much. And I was very, very elated that he was trying to bring the conversation to a very elevated position of constitutional rule. That when a decision is against you, you don't sit in your bedroom and say that, look, I found this decision distasteful and I'll disobey it with impunity. That is lawlessness coming from whoever. And if you pay regard to the decision, it is so clear that even the President and the Speaker are subordinated to that book, which is called the Constitution. And nobody is above the Constitution. So with the greatest of respect, if you look at it from every permutation, I don't believe I'm going to do a disquisition of what they've done, because that is a long essay for everybody to do. But in trying to educate the public, if you look at it from the dissenting view, Speaker Backbone is not clothed with judicial powers to determine who is a member of Parliament or who has vacated the seat.
Very well. Let's take it this way. So now, from starters, we went to the court on Article 2.1, and Article 2.1 talks about the fact that a person who alleges that any act or omission of any person is inconsistent with the Constitution, etc. The view that has emerged since is that Afenyomakin went to court at the time the act being complained of now hadn't arisen, and he did not go back to amend the facts to reflect the conduct of the Speaker. At the time, the Speaker hadn't come out to say anything, and so his going to the court and the court assuming jurisdiction over the matter was inappropriate. Just clarify that for me.
Why is it inappropriate? Because Afenyomakin was trying to talk about a scenario in which the filing of processes for a future political alignment may be construed as vacating the seat. That's what he was trying to project. And therefore, if we want an understanding of which forum should we go, if you want to know as to whether or not your mere filing of processes to determine where you will be in terms of political alignment in the next parliament, should constitute a vacation of your seat in terms of Article 97. Which forum should go and interpret it? Is it the carpenter shop or the MPP headquarters? It doesn't accord with common sense to say that the Supreme Court cannot look at this matter. And guess what? There is a more serious matter which happened thereafter, in which the Speaker actually made an adjudication on the matter. So it came to the attention of the the Supreme Court in the course of the proceedings. And then when the decision was handed down that he should bring the status quo back to where it used to be, the same speaker commandeered the lawyer to come before the Supreme Court to set aside the decision. So all these matters have come before the Supreme Court. How can the Supreme Court ignore matters that have come before it? I do know the Supreme Court can found a decision not based essentially on an issue raised by the party. This is a constitutional matter that pops up in the course of adjudication. The Supreme Court should deal with it so that we don't have piecemeal litigation. So people are looking at a very technical emptiness of what, probably Afenyomarkin did, but rather will not look at the substantive matter which will come before us for a long time as to whether or not a Speaker of Parliament can graduate into a Supreme Court and make a pronouncement which is virtually like determining constitutional interpretations and the rest of it. This is the point that we should all look at, and it's very critical.
Very well. Beatrice, you wanted to make a point. Is it in respect of 2-1 and the fact that the act hadn't occurred at the time?
I think that with all deference to my learned senior Atachia, he completely missed the point about this whole case. And I saw his name as part of the people who appeared. I don't know whether
Jogate, Abedu, and a few others.
Yes. You see, what we are talking about is not that the Supreme Court does not have jurisdiction to interpret the Constitution. In fact, you don't need to go to law school to appreciate that when it comes to interpreting the Constitution, the Supreme Court has jurisdiction. Now, everybody was taught in law school, and we all know that the jurisdiction of the Supreme Court can either be original, appellate, or reference. What the contention has been, and what every reasonable legal mind has asserted, is that the Supreme Court did not have original jurisdiction when it comes to the determination of a matter of vacancy or otherwise in Parliament. And the Supreme Court has had a long line of cases in the Bimpombuta versus Attorney General and many other cases that even when you clothe a different matter as a constitutional matter and you bring it to the Supreme Court,
and in reality it is a
yes, and in
matter.
reality it is not a constitutional matter. They have the duty to, lift that veil, for want of a better expression. Now, before I even deal with the merit of the case, because Senior Tachia has dealt with jurisdiction, let me tell you one embarrassing thing the Supreme Court did when they sought to clothe themselves with jurisdiction. On page 10 of the judgment of the majority opinion, the Supreme Court said, the resolution of the jurisdictional issue on the fact of the instant case involves a determination of a two-pronged query. First, whether or not the conduct complained of against the first defendant falls within the purview of our jurisdiction. That is the first one. Selorm, Honorable Atachia is a lawyer in the case. Can he point to us where exactly in the case they complained about the conduct of the first defendant? That matter was never put before the court.
Honorable, I'll come to you. So
no, he can answer that.
You may want to make notes.
Yes, he should answer
just want
that.
you to flow. No, just flow.
He may want to answer that. In fact, he should answer so I proceed.
Honorable, if you are minded to.
Yes, my good friend has not paid regard to the issues raised, especially the issue raised by the Attorney General. And the issue raised by the Attorney General is clear. Whether the decision of the Speaker is subject to judicial review. It's an issue, part of the memorandum of issues. Please, please. So, it came up strong. It came up strong that the Speaker's conduct was part of the issues to be determined by the Supreme Court.
So, yes. So the answer by the learned senior further shows how flawed the entire proceedings before the Supreme Court is. Selorm, why do I say that? You can only put issues before courts, issues based on which pleadings have been filed. So how is it that you go to court? You do not plead some matters. In fact, it was not even contested by the other party. But some way, somehow, you found these matters as issues for you to raise. Where from that rule of procedure? Malena Senior has practiced for years before I was called to the bar. Where from that procedure?
Madam,
you let me make my point. That it was never part of the matters put before the court. And you know what they did? This was not the only issue that was not pleaded, but was made an issue. When you look at the writ by Afenyo Markin, he never mentioned anywhere that a declaration that the NDC MP, Honorable Peter Kwache Aka, his seat should be part of the declaration. So when you look at what they were asking, they were only asking for declaration in favor of the 3 NPP MPs, for want of a better expression.
No, I thought they did. Though.
They didn't. It was nowhere in the relief sought.
So okay, so it came up in the issue.
It came in the issue. Where is it that you go to court? You don't plead some factual matters. In fact, when you go to court in the Supreme Court, you just don't issue the writ like you do in the High Court. You add an affidavit of verification, verifying that the matters which you have pleaded or deposed to are the factual basis. It is on that basis that even the first and second defendants will now have to come and respond to. But you went to court, never pleaded any of these things, and you said that suo even though I did not plead, I have raised this issue, so I'll address them. If you address them, you address them on what factual basis? What references should the court make? So the point I was making is that, first of all, the court went into extrinsic factors, and I am tempted to believe that by reason of this, the Supreme Court judges were either watching TV or watching the proceedings in Parliament. Otherwise, how did these matters come to their notice? The court is a court of record, and the Supreme Court can just merely not say that we have heard in the media, or it has happened in Parliament, that these are the facts, or this is the decision of the Speaker. And so based on that, we will set an issue and say that whether or not the act complained of, who complained of this act? There is nobody who complained of this act. So that first one, they got it absolutely wrong. And you cannot build something on nothing. So to the extent that they formulated the wrong questions which were not before them, and then they sought to answer, you will know where we are going. But it gets even more interesting on page 14. This is the decision of the majority. And I want to read that the suit essentially hinges on a pure question of law. Specifically,
page 14.
Yes, the last but one paragraph.
Okay.
The suit essentially hinges on a pure question of law. Specifically, the proper construction of Article 97 1G and H to establish the legal threshold for triggering its provision. Here is where it gets even more interesting. Without delving into factual disputes regarding seat vacation in Parliament, which properly lies within the court's purview, which properly lies within the High Court's purview under Article 99 of the Constitution. So the Supreme Court itself is saying that this suit lies within the purview of the High Court.
The factual basis of the suit.
But you see, whether or not a member has vacated the seat, it's not a matter of law. We are all lawyers.